Good afternoon, everyone. Welcome and thanks for joining us at the DAYL Trial Skills Committee's Spring CLE program, all about the pretrial hearing. We're excited for the excellent panel we have today, and we hope you'll come away from today's event with insights you can apply in your practice right away. Before we get started, I want to quickly mention our upcoming program in June, which is the Top Gun Trial Skills Academy. We have partnered with the DBA to host a boot camp style all-day CLE on June 26th, which will be held in person at the George Allen Courthouse from 9 a.m. to 4 p.m. The trial skills we're going to cover are voir dire, cross-examination, and closing arguments. We're going to have some of the top gun litigators in tort, commercial, and criminal litigation have panel discussions about these skills and also demonstrate each specific skills for participants to observe. And after watching some of the best do what they do, you can practice your newly learned skills by giving a closing argument in front of real judges and seasoned attorneys who will give you valuable feedback. It's designed to be a deep dive into the nuts and bolts. It's free to DBA members, and we hope you'll join us on the 26th. And we're going to have the registration link for that event in the chat. Now it's my pleasure to introduce our panelists today. First, we have the Honorable David Horan, United States Magistrate Judge for the Northern District of Texas. Judge Horan took the bench in the Dallas Division in 2012. Prior to his swearing in, Judge Horan was a partner in the Dallas office of Jones Day, where he led the firm's issues and appeals practice group in its Texas offices. Judge Horan has written articles on federal civil procedure and discovery. And he's also the author of a legal writing book called Bad Words, A Legal Writer's Guide to What Not to Say. Next, we have Andy Payne, a partner at Payne Mitchell Ramsey Sanger. Andy routinely handles significant newsworthy personal injury cases across the country. He has been lead counsel on numerous cases ranging from aviation, product defects, medical malpractice, and other injury matters. He is double board certified in both personal injury trial law and civil trial law. He previously served as president for the American Board of Trial Advocates and is a fellow of the American College of Trial Lawyers. Last but certainly not least, we are pleased to have Jervon Newsom, a partner at Winston & Strawn. Jervon has extensive experience in complex civil and business litigation, handling matters at both the trial and appellate levels. She represents a wide range of clients from Fortune 500 companies to small businesses, and she's known for her practical approach, strong work ethic, and creative problem solving. Her excellence in the field has garnered her recognition in the Best Lawyers in America, Texas Super Lawyers Rising Stars, and D Magazine's Best Lawyers Under 40. Thank you to all of our panelists for being here and for sharing your time and expertise. For those of you who are watching, for our attendees, please feel free to submit any questions for our panelists by using the Q&A button, not the chat feature. But if you press on the Q&A button, you can submit questions. And if time allows, we'll address some of them throughout the program. So on to our first question. Judge Horan, let's start with the big picture. What's the purpose of a pretrial hearing or a pretrial conference?
Sure. Thank you. And thanks for letting me be a part of this. In federal court, we tend to call it a pretrial conference or final pretrial conference, and it's governed by Federal Rule of Civil Procedure 16E specifically. And the purpose, as that rule lays out, is to come up with a trial plan, handle all pretrial matters to try and the conference is held as close to the beginning of trial, and if it's a jury trial, jury selection as we can. Our judges' practices differ, I think, a bit. I tend to hold them the Friday or Thursday immediately before a Monday launch of trial or jury selection. And the idea is to talk about trial logistics, make sure if I haven't ruled in advance on motions in limine that have been filed or other motions that deal with what will happen at trial. If I haven't already ruled on those in the paper, hear argument or discuss those with counsel and get rulings on those. Pre-admit exhibits, discuss order of witnesses, what witnesses will actually be called. Having at least one witness possibly attend remotely or over Zoom is becoming more and more common, frankly, and making sure those logistics are all worked out. And then out of all that, I then will issue the final pretrial order. And under the federal rules, that order then governs everything, including it supersedes the live pleadings at that point and controls what's at issue and what the claims and defenses are in the case at that point.
Okay. And Andy, as a plaintiff's lawyer, what are your goals coming out of a pretrial hearing?
I think a pretrial hearing, from my perspective, one thing I want to do is know what evidence, to the best that I can, is going to be evidence that I can talk about in the opening statement and the trial itself. And so those issues that are unresolved, those evidentiary issues that are unresolved, you want resolution to, so that you know how to try the case. And to me, pre-admitting exhibits is enormously important, and getting either agreements or understandings from the court that those pre-admitted exhibits can or cannot be used in the opening statement, so that you know whether or not I can put that in a slideshow. I can put critical documents that are pre-admitted into a PowerPoint slideshow that I might use in an opening statement. If there's deposition designations, you've got to get those cut, and you need to know what those witnesses are going to say and not say, so that you don't deliver or make a promise in your opening that you can't deliver on because the judge, cut your deposition in a way you didn't like. Same issue with motions in limine. I try to limit the issues as much as possible. I think it's critical for you to get together with the defense lawyer, narrow those issues down. So really, you're going into the judge saying there are three main issues that are still in dispute, and here's how it manifests itself in depot designations or motions in limine or exhibits, and get clarity on that. And then finally, I think there's the logistics. Make sure you know how to run the trials presentation software or system that the court has. Those vary from courts to courts. Make sure your computer works. Introduce yourself to the court reporter and the bailiff. Get an understanding of how they're going to seat the jury panel, so that you've got a seating chart and how that's going to occur. Hopefully, if you're asking for a jury questionnaire, you're working out the logistics of the jury questionnaire. I wouldn't ask for it for the first time at the pretrial. You might not have much success at getting it. Likewise, in state court, we often request a larger jury panel, so that the judge is not as likely to be skittish on granting challenges for cause. If you've got a bigger panel, there's a better chance you're going to get your cause challenges granted. So some of those logistics are things that, the number of jury panelists and the jury questionnaire. I would recommend you do that well in advance of the pretrial, but you need to make sure that those issues are resolved at the pretrial.
So, Jervon, going off of the kind of opposite side of it, I know that in your practice you represent both plaintiff and defendants, but when you're representing a defendant, are there any goals or strategies for your pretrial hearing that are different than when you're on the plaintiff side?
For the most part, and thank you everyone for having me as well. For the most part, it's pretty much the same. However, everybody knows that the plaintiffs get to go first. And so sometimes who tells their story first, you feel like they get an edge. So from a defense standpoint, you don't want to be so lenient and so agreeable to plaintiff's attorney putting in all their evidence in an opening statement. Some things you want to make plaintiff work for and actually have a foundation or some witness sponsoring that particular evidence to bring it in at the appropriate time. So if there's some key evidence that you don't really want out there in the opening statement, then at the pretrial you're going to do your best to try to make sure that that's not a pre-admitted exhibit. Now, I'm not saying go in there and just be, combative during the pretrial and not agree to anything. There are certainly things that you should pre-admit and agree to, because as a defense lawyer, you want some things to come in automatically as well. So I would just say it depends on your structure of the case. If you have really, really good evidence on your side as well, then maybe you're not fighting so hard for to keep pre-admitted exhibits out of plaintiff's opening statement. But if you know you don't have the good evidence like the plaintiff, then you might want to really object. That may be your main strategy during pretrial, is to bring all of the case law and the support you have to make sure that plaintiff is not getting a chance to shape the case the way they want to shape it. And I'll say this last thing. Pretrial is your last opportunity before the trial, pretrial conference, to see what the case is going to be, to see how it shapes, and for you to interject how you want it to play out, even as a defense attorney. So don't go in so agreeable. There may be some things you got to make plaintiff work for, and I typically would do that if it's evidence that I don't want them to use in their opening statements.
And this is implied in both of your answers, but basically what you're getting at is if certain things are pre-admitted, then it's free to be used during opening statements.
For the most part, and you want to make sure that you, as Andy said, you want to make sure you get that agreed upon in front of the judge. You know that you're giving your opening, because I may not know that you were going to use it, but some judges require you to show me your opening statement, your PowerPoint that you're going to use, so that we can know. Because the worst thing you want to happen, and I'm sure Andy can attest to this, is that somebody's objecting during your opening. You don't want that. So be open, let people know let the other side know what's going on, so you don't have that interruption.
And Judge Horan, from the court's perspective, how much time is usually allotted for a pretrial conference, and what's the best way for lawyers to be efficient with their time during those conferences?
Now I typically, I honestly, I block out like 4 hours, but I've never had one go 4 hours, and that that would be troubling outside of a really complicated case. But they're typically going to be, at least an hour. That's pretty common for a relatively straightforward case. I've certainly had pretrial conferences go to 2.5 hours, and as both Javon and Andy have been saying, it's just really important that I want everything resolved as much as possible at that conference and the final pretrial order, so that I try to put in a bunch of work on the front end, and required of the lawyers as well, of course, so that by that, really, again, if trial's kicking off, as it usually does on Monday, by that Friday afternoon, and all that is squared away, and now it's time for evidence, right? Now it's time for picking the jury, getting the jury in the box, or if it's a bench trial, either way, and getting exhibits in that weren't pre-admitted, and putting on the evidence through witness testimony, and we try and do as much work as we can, even sort of some initial discussions possibly about even the jury charge, there at the pretrial conference, or at least get expectations of how that's going to play out. Because I want us to be working on that early in the trial as much as possible. So again, when we're starting to run up on the close of evidence, which in my experience often comes faster than everyone's initial predictions anyways, right? Witnesses start sort of falling away, as things become clear to the trial lawyers that maybe a few of the witnesses are going to be sort of redundant and unnecessary. And then, next thing you know, everyone was talking about closing evidence on Friday, and it's looking like it's going to be Wednesday afternoon. We want to be ready to, get the case to the jury as soon as possible. So I want to devote as much time as I need to, and as I think that the lawyers and the party collectively should at the pretrial conference, to accomplish all of that.
And you mentioned the jury charge. How often do you see the jury charge look different at the time that it actually gets submitted to the jury versus what the parties start with at the pretrial conference?
Almost. I can't think of a time it didn't. So there was some changes are bigger than others. I require, some of the judges here do this as well. I know different judges take different approaches. I require a joint submission of a full proposed jury charge with the final pretrial materials that the final exhibit list, witness list, all that. And that's usually required about 3 days or so in advance of the final pretrial conference. And yeah, it's required the parties to put that in one document, agree in as much as they can, and then sort of highlight, like bold for one party, underline for the other, where there's competing provisions or competing instructions or jury questions. Depending on how much agreement there is there, some of that has to do with how far, how big the changes are going to be by the time it's ultimately done. But the jury charge is ultimately the judge's and the court's responsibility. I mean, and so I want as much input from the lawyers on the front end, and as much as they can agree and do a lot of hard work on the front end, the better. But at the end of the day, it's the court's job to get the law right and get the instructions to the jury right.
And Andy, when you're going into a pretrial hearing, what kind of motions do you prepare, and do you proactively file or prepare any briefs, or do you wait until the judge requests briefing on certain issues?
No, I think it's if there are issues, I think it's smart to come armed with some trial briefs that you can give to the court in advance of the trial, so they have an opportunity to look at those things and consider your position, as opposed to here's the trial brief on the witness that I'm fixing to put on the stand. They're not likely able to even look at that, and you're going to have to make a decision on the fly. So, I think you want to arm the court with the information that they need ahead of time, and give them sufficient time to look at it. So if there are those issues, I would do a trial brief and just alert the party to it and say, this is when it's going to come up. You give it to the judge, you give it to the other side, or, these days you file those electronically, but maybe bring a copy to the pretrial to remind the judge that it's going to be an issue and you want to look at it. It's not in every case. I mean, there are some times that those issues may not occur, but certainly if there is a disputed issue or there's going to be a legal issue that comes up, I think it's a great time to remind the court of it.
And are there any motions you typically file for pretrial other than just a motion in limine or something like that?
In federal court, certainly I'm going to file a motion allowing me to do voir dire, and in the absence of a court that will allow me to do voir dire, questions that I would like the court to consider in their voir dire. So that's more federal court related than not. I think a motion for commonly extended time on voir dire. Voir dire is critically important from I think the party's perspective, really, on plaintiff and defense. So it would be typical that I'm going to file a motion for an expanded time for voir dire where appropriate, to do voir dire at all in federal court. And you want to do the homework on your judge ahead of time. Do they let you do it, or do they not let you do it? The motions in limine would of course be standard. And I say standard, I try to have my non-standard motions in limine be at the front of the motion in limine, and it be the first 3 to 5 that are the ones that we care about. The ones at the back of the motion in limine are what I think are more of the standard, no collateral source. You can't talk about certain things that everybody's going to agree on, insurance, those sorts of things that would be contained in there that generally the parties are all going to agree to, and you just want to have a record that the other side can't go into those things and essentially get an agreement to that. But you really want to focus the judge on the 2 or 3 motions in limine that are in dispute, and perhaps provide briefing as it relates to those specific motions if more detail is warranted.
And Jervon, since our audience here is mostly younger lawyers, if they are not actually speaking at a pretrial hearing or participating in that way, what's the best way that young lawyers and associates can help you prepare?
So yes, there's lots of ways that associates can help prepare. First and foremost, you got to know your partner, who's the lead counsel on the case. You got to know what their preferences are. So you should know this way back 2 to 3 months in advance. You know that this pretrial hearing is coming up. You know that you're going to have to put together exhibit lists, witness lists, do depot designations, all of the works. But the worst thing that can happen is you don't know how the lead counsel wants it to be presented to them, and so they can help them during the pretrial. So 2, 3, 4 months in advance, go talk to the partner on the case, the lead counsel on the case. Say, hey, do you have an example of a trial notebook or some type of pretrial hearing documents that would help me help you when we get to that level of how you want this organized and how you want us to be thinking about the case going forward. So do that first and foremost. Know what your partner wants, and then also get to know that judge. So know what the judge's preferences are. Go and read the pretrial instructions from the scheduling order or the docket case management order, figure out exactly what the court is going to require, the deadlines, and all of that. All of that should be done 2 to 3 months in advance. And then you should know what the issues are. You've been in the case long enough. You know what the issues are. You know what the pain points are. You know what opposing counsel is going to be arguing or trying to keep out or trying to put in. So there should be some type of documentation already available where you're putting these notes in a continued document that you're just updating from time to time on. This is going to be a pretrial issue. This is going to be something we're going to have to deal with. And as Andy said, you'll know what you need to do in terms of the trial briefs, additional research that needs to be done by that time. And when we say trial briefs, we're not saying, hand the judge a 20-page document. They don't have time at that point to be reading a 20-page brief. But more than likely, you have briefed these issues prior to at some point, or you've disclosed this to the court that this is going to be an issue. And a trial brief is something, maybe like 2 to 3 pages of why this needs to go, what our position is on this. So I just say this, as far as what the associates can do, get it organized. You know the case in and out better than anybody else on the case. So get it organized. Talk to the partner as to what their preferences are. You ought to know that scheduling order and the judge's preferences more than anybody. Go talk to another attorney. Send an RFI out to your law firm and say, hey, has anybody done a trial in front of this judge? So that you can know what to expect. And if you can do all of that work on the front end, about time it's time to, put a witness list together or the exhibit list together, you have a good understanding of what the partner wants, what the judge is going to require, and how to organize it because you have examples on what the partner used before. So that's what I would say is start early. Start early because speed is of great importance in these pretrial hearings.
Judge Haran, was there ever a time where you remember being really impressed by the caliber of lawyering during a pretrial conference or really effective situations that you've seen lawyers handle, whether it's about when a lot of exhibits are not being agreed to or anything that stands out in your mind?
Yeah, many times. And I think it really, I just focus on a lot of the same things that Andy and Jabron have been saying. I mean, as much as pretrial conferences, like I say, it's really a practical exercise, right? I mean, we're trying to accomplish getting everything squared away, like I said, ultimately my goal is the parties through their lawyers are able just to put on their cases. I mean, I want lawyers to be lawyers, and this is what you do. It's not my case. It's each of the parties' cases, and so being able to reach agreement on just sort of practical solutions to things. I mean, I can remember a trial in the last, I don't remember which one, but sometime in the last year where at some point there were a bunch of witnesses, but some of them were going to be kind of redundant, and the two lawyers just ended up getting together there at the podium, just sort of going through the list together and just sort of making agreements on knocking it out. And I'm very happy for that to be happening right in front of me, right? I mean, because that we're getting to the end result that is what's going to make sense. So yeah, I think being solution oriented, really, and keeping in mind what's really important, right? I mean, what's the evidence you really need? What's the story? What do you need by way of documents and witness testimony to tell your client's story and get in the evidence that you need for your claims or defenses, and that are ultimately going to matter for what the jury is instructed on and asked about. As long as you can keep all that in mind, and keep in mind that that's what the court's doing. And for me, it continues throughout. I mean, I'm not dictating to the parties what witnesses they put on or anything remotely like that, obviously. But I do ask for sort of updates as we go along. Like, okay, who are you thinking about next? Or what are we looking at? Who are the witnesses tomorrow? Just because, again, I mean, I have a role to play as the judge and the court in the case, and the more I just have some sort of information, a continuous stream of information about what I can expect, what the which witnesses are coming, um, and what everyone's thinking in terms of schedule. So that's an ongoing conversation that starts at the pretrial conference and continues every day throughout. So that lawyers keeping all that in mind and realizing that that's kind of the best mode for us is what I find most effective.
And
So
can I
sorry.
add something to that? I just want to add that the judge brought up a very good point. As the attorneys, we kind of think about our case and what we're doing, but the court is also working. Okay, the court reporter is working. She or he is working all night to do the transcripts, and sometimes we want a copy of that transcript to use for the next day. The judge is trying to make sure that the jury is taken care of, that there's jurors calling it at 9 saying they're in traffic. So we just need to think about the fact that the court is doing just as much work, or probably more, than what the attorneys are doing as well. And so if we keep that in mind, that this is a team process, right? And we want to be as helpful to the court and the judge to doing what he needs to do or she needs to do to take care of the jurors, to make sure the court reporter is okay, to make sure everything else is running smoothly in terms of exhibits. So I think that's a really good point, is, there's more to it than just what our case and what we're doing. There's the judge and the jury and, the court, they have a significant role to play. Sorry, I just wanted to add that.
No,
Oh, no,
and
yeah.
I'm going to jump in. I'm going to jump in too, because I do think that y'all both touched on a very important thing, that ABOTA is a big advocate for, and that's civility. We're adverse to one another, but we can do it in a professional way, and we can handle things in a professional way. We can agree to pre-admit exhibits, and if the defense lawyer says, "I'm going to agree, but I don't want you using this during the opening statement," well, just tell me that, and then we can go talk to the judge about it, and they're either going to let us do it or they're not going to let us do it. You can play games with what witnesses you're going to call the next day, and act like you're going to call different witnesses so they prepare for the wrong people. That's a terrible way to practice law. You need to you don't have to give them your whole trial plan for the whole 3-week trial, but as a matter of professionalism, you need to say, here are the witnesses that I'm going to call tomorrow. Here are witnesses that I may or may not call. I haven't decided yet. I probably will. I probably won't. There's a lot to the idea of being professional, with the defense lawyer, with the court, and it will make your life so much better, as a trial lawyer, if you're not just beating your head against the wall unnecessarily about things that you really shouldn't be doing that with. So sorry to hop on the soapbox a little bit there.
No, not at all. I think our audience really appreciates that insight. And from what I'm hearing you all say, is it fair to say that it is not a good use of advocacy or in your client's best interest to just dig your heels in and refuse to agree to anything just to be difficult?
Absolutely.
Yeah, absolutely.
Absolutely. Yeah.
And
I'm sorry, Irma, I don't mean
go
to.
ahead, Jeff. No,
There
go
was
ahead.
one other thing I meant to mention earlier, and it goes along with this, is another issue that does come up that I bring up at every pretrial conference, is asking whether either party is going to invoke the rule of sequestration of witnesses. And typically somebody does, and that's fine. It's helpful to know in advance. And uh, what I always do tell the parties, and I did actually have this come up, or an alleged violation of this in the last year, but again, another thing to sort of keep in mind about everybody's roles and sort of information asymmetry is I don't know what your witnesses look like mostly, right? I mean, it's like I just why would I? Unless that we've had some evidentiary hearings or something in advance where I might have seen some of them. Certainly by the point I know what the clients or client representatives look like, and they're sitting there in the trial, and they're not subject to the rule anyway. But um, yeah, so and neither do, to be clear, my courtroom deputy or the court security officer or in state court the bailiff. So what I always do remind the parties, I need y'all, if somebody's going to invoke that, I need y'all to police it. Because there's people coming in and out of the courtroom. I got a lot going on. I can't be, I can't be interrupting the trial every time somebody opens the door and walks into the courtroom and asking if they're supposed to be there or not. So it just as a practical matter, and this actually I think is relevant for younger lawyers who might be there in the courtroom not as the first chair, but sort of running things that just it can be a really important thing for the parties to and the lawyers and your entire team to kind of keep in mind, both giving clear instructions to your witnesses, but also just kind of keeping an eye on who's in and who's out. And like I said, we actually did have this issue come up and did get to do some research on the fly on what exactly happens if somebody has allegedly violated the rule of witness sequestration. So that's an experience I don't wish to have again. And I wouldn't wish on anyone. So
And
just one practical tip.
and to
Really
that
helpful practical tip. Go ahead, Jervon.
And to that point, to Judge's point, the other thing that comes up is attorney's eyes only or
Mm.
confidential information. So that needs to be discussed at pretrial as well, how you're going to handle that. Because I know I was in a patent case not too long ago, and the court had to close the court when certain information was being discussed on the witness stand. So as associates, as younger lawyers, you want to be on top of that. In terms of the pretrial hearing, understanding how the judge wants to handle that. It may be an argument. It may be de-designated by that time, which most of the time it is. But that is something else that you want to think about, invoking the rule, as well as if you have any attorney eyes only or confidential information that is going to be presented and how that's going to be presented in the trial.
Very helpful to keep in mind. So Andy, what has generally been your experience, or do you have any tips about how to handle it where there are a large volume of exhibits that are not agreed to? And is it a good idea to have a large volume of exhibits at all?
Well, I'll say that I've evolved in this. I mean, I think typically what happens is a paralegal in the office will create an exhibit list and they will be over inclusive so as not to be accused of leaving off something important, and will include every medical record, 12 boxes of medical records, every scrap of document that was produced by the defendants, every deposition exhibit. And it really, to me, the exhibit list and the evidence, that's what the lead trial lawyer really needs to focus on. What do I care that this jury see? And I put it in a form that makes it easy for them to see it. And so rather than have a large volume of exhibits, I had an experience 10 years ago or so where I was trying a case, a complex products liability case, and the defense lawyer had 10 exhibits. I think he's one of these guys that had tried 500 cases. He was a great lawyer, but he had 10 exhibits. He didn't have the whole operator's manual that was 500 pages. He had the 2 pages out of the operator's manual that mattered. He had the 3 medical records that mattered. And what that does is it allows you to have maybe a notebook. You put it in a red notebook and you number the exhibits. And during your closing argument, you can stand up and say, here are the exhibits that are the important exhibits that I want you to look at. You'll see behind tab number 1, there is the owner's manual and the key provisions of the owner's manual. And you can put it up on your PowerPoint presentation and discuss it. If you have questions, ask for this red notebook, or it will be back there with you in the jury room so that you can look at it. And so you can really direct during your closing argument the jury to look at the exhibits that you want them to look for, as opposed to the bailiff delivers back to the jury room 40 banker boxes that nobody is ever going to look in and in no particular order. Mark Lanier, who is a generationally great trial lawyer, recommends that you number those exhibits thoughtfully. Your very most important exhibits, exhibit number one. Maybe the smoking gun document that shows that the defendant acted bad is exhibit 666. You get exhibit numbers that have maybe those meanings that the jury's going to jump out and say, we need to look at exhibit number one, or I'm going to get back there. I want to see exhibit 666. I need to look at that one up close. Whatever those things may be or important. There's also, I think, a trick that a lot of lawyers use. If there's the photos that maybe are persuasive, now here's some photos and they're gruesome, and I'm going to put them in an envelope. And so just be careful that they're here. And we want to be respectful of you that you don't go back and look at those, and that's the first thing that they're going to look at. Using some thoughtful analysis and really limiting down what you need to actually try the case, and putting that in a form that is useful to the jury is important, as opposed to just over inclusive. I'm not going to get fired so that I have everything in the whole file in front of the jury. And you really do the same thing with your witnesses. I mean, you take a 6-hour deposition and it turns into a 45-minute direct examination and a 30-minute cross-examination. Do the same thing with your exhibits.
So it's generally not a good idea to just throw everything at the wall and see what sticks.
Yeah, I think that's right. Absolutely. Now, the appellate lawyers may scream at you down the hall, and so you have to be mindful of what the appellate lawyers are going to get mad at you about. But from a trial lawyer standpoint, I'm only interested in the things that are going to matter in telling my version of the case, my story. How am I going to prove that in a persuasive way?
Jervon, is it really possible to win or lose a case at a pretrial hearing? And if the answer to this is no, it may put some of our younger lawyers at ease when they're going into this. But in your experience, what it would be a situation where it really could make or break the case, and how do you course correct if you need to do that?
So I live by the mantra that it's not over until it's over. And so I think that if you do have a bad day at pretrial, who knows what may happen during trial. You can get somebody on the stand and they're having a bad day and they just may admit to everything you wanted them to say, and now you're on the better side of things. So never admit defeat during the pretrial. If that one document that the court says you can't get in, if that was your entire case, then you should have been thinking about settlement, 3 or 4 months ago, if you were hinging everything on one particular document and the court doesn't let it in. So no, I think by the time you get to the pretrial hearing, you know the strength of your case. You know that it's strong enough, whether you get something admitted or not, pre-admitted or not, or whether you get a certain witness that you can bring in or not, whatever, motions in limine. You'll know the strength of your case, and it ought to be strong enough to continue to go forward if you've reached that point. I will tell you though, I do have one example where we had a trial coming up, and we had the judge. He ruled and said that this evidence was not coming in, so we felt pretty good from a defense standpoint what the plaintiff was trying to get in. And then there's another judge. Another judge came onto the case and decided to let all of that evidence in. Now that was a moment where it threw us off, and I think at that point the client had decided to engage in settlement discussions because the evidence was pretty tough. But that wasn't, it wasn't any fault of not being non-prepared or unprepared. It was we had a new judge that came in and said something different, and we could not have planned for that. So that's the only example I will give you that where it's very rare that you will just lose something at a pretrial hearing that will impact your case enough where you have to go crawl up under a rock. I don't think that that's the case. So the best way to course correct is by the time you get there, you already know the strength. You know where you need to pivot. You know, okay, we didn't get this in, so now this is our main document. Now this is our main witness. Now this is our main testimony. And it's not over until it's over. You can do something during trial that will open the door to something that the judge may have said is not coming in. If you get that witness to say something that they shouldn't have said or shouldn't say, you can revisit the issue. So that's why I say it's not over until it's over. You have a full trial to go. It's sort of like a basketball game or a football game. You know, there's 4 quarters. You're gonna play each and every one of them, and only at that buzzer is when there's a decision to be made. So keep trucking, keep pivoting, keep doing your thing. It'll be fine if you lose 1 or 2 things at pretrial.
And this is a question from one of our audience members. And they're asking, what is your advice for dealing with opposing counsel who practice law the way that Andy was saying we shouldn't, playing games, creating unnecessary complications in the case? I think this is something a lot of young lawyers struggle with how to handle. So what are all of your insights and advice for how to handle those kind of situations?
My thought is, and I didn't mean to jump in front of the judge on this. I think you continue to practice law the way that you should practice law. You continue to do things the right way. And you know who's going to figure that out real quick? The judge. And, lawyers always talk tough until it's time to go down to the court. And they may take unreasonable positions, and you can say, well, gosh, I just disagree with that. Let's see what the judge thinks. And then all of a sudden, they're either going to be more reasonable when they get in front of the judge, or the judge is going to recognize that they're unreasonable, which is better for you to begin with. But that's why the court is there. And so, I think sometimes you may get a bully that wants to push you around, particularly as a younger lawyer. And, don't be afraid to go have a hearing in front of the court. Don't be afraid to bring the matter to the court. And usually that will resolve it before you even have to go to the court. But it's a long game. I've been practicing, I think, 32 years now, and your reputation is enormously important. You do that type of stuff as a young lawyer, and you'll get the reputation as the litigant who does that. And then you're going to be treated differently by the judges, and they're not going to give you the latitude that if you don't do that. They know that you are a good lawyer and a professional, and treat everybody correctly the way that you should. You're going to get better treatment at the court. You're going to get a better treatment with the lawyers you go against. And frankly, I think you get better treatment with the jury. People want folks to win that they like. And if you're not a likable person, it's harder for you to win. So there's all kinds of reasons to not give into that. Just keep doing the right thing. Now, Judge, tell me what you think about that. Sorry to jump in on you.
Oh, no, that was great, Andy. No, absolutely. I agree. That's right. I mean, you got to continue. Don't shift, who you are or what your approach is just to match. We're not looking for sort of lowest common denominator, ways of practicing law from the court's perspective. And yeah, continue to do the things the right way. Be transparent with the court about what's going on, but without being accused. You don't need to get into name calling or accusing. It's the same thing advice I always give on sanctions motions. We don't really want to see motions for sanctions, but they're sometimes necessary, and we get them. And my advice has always been, just lay out the facts, right? Just dispassionately lay out what's happened. give a timeline. This is what's happened. We asked for this. They wouldn't agree. Whatever it is, and trust that the court will figure it out. And let the court be the one that gets mad and decides what to do. But I completely agree with Andy. If you continue to do things the right way, and as necessary, bring it before the court and just sort of lay out what's going on, then yeah, I mean that's what the judge is there for, and we'll make appropriate rulings and kind of rein things in as appropriate. But it, definitely, it doesn't do. It's not in anyone's interest if one lawyer is acting that way and then the other lawyer decides they need to get down in the mud and sort of match that. That's a recipe for disaster.
Jervon, do you have any thoughts on that or?
No, I mean, I'll say amen to that. So I have nothing else to add, except just document. I think documenting behavior or conversations is very important. But you don't want to, do it, and do not do it on the judge's email. So again, I know
Yeah.
this doesn't really happen in federal court a lot, but in state court, sometimes the judge may email or the court staff may email, and then you got a big argument between the two parties on what was said. Do not do that on the judge's email, but document separately if there's a discussion you had and they said something, and say, hey, I just want to, kind of put a record to our conversation. I asked you, would you be amenable to this? And you said no, or whatever, just kind of document it. But, and like I said, amen to the rest of the stuff they said.
And it's rare, Javon, but that does happen in federal court. But
Oh, wow.
it's oh
Okay.
yeah, no, but it's really rare and it's not welcome.
I could.
Yeah.
One thing I would encourage young lawyers to do is pick up the phone and call. Don't live life on email.
Mhm.
Pick up the phone and call the opposing counsel and say, "Hey, I just want to visit with you about this case." That goes a long way. I had a situation last year where it was a big oil field case. There was good lawyers in the case, and there was one young lawyer, and everybody was getting real frustrated with this young lawyer because they were taking a 6-hour deposition that should have been a 1-hour deposition. And everybody knew it there, but we've all been young lawyers at once, and maybe we're not as patient in the moment. And it's okay to pick up the phone and call somebody and say, "Hey, I wasn't as patient as I should have been yesterday. I hope you'll forgive me." Um, Man, you just that one conversation is going to change how that person reacts to you the rest of not just that case, but the rest of your career. And so having those kinds of moments, the respect that you have for the other side and their abilities. I have good lawyers that will call and say, "Gosh, you did a great job during the deposition," or I'll let them know, you gave an amazing closing argument, whatever it may be, and that can be true even though they're opposite you. Our system is a wonderful system. The jury usually gets it right, despite how good or bad the lawyers are. And so, I think we put a lot of pressure on ourselves as lawyers. And if you go in a professional way and you have fun and you do a good job and you tell the story the best that you can and you're prepared, it's generally going to work out like it should. And sometimes that may be for you, sometimes it may be against you, but don't get too stressed about it.
And to Andy's point, the phone calls, sometimes that's required. So know the local rules as well, that living, just sending a conference or a meet and confer or something on, through email may not work for that particular jurisdiction or that judge. But then it does still go a long way for, just making sure that you can just have that cordial relationship with the other party. I agree, that goes a long way.
Can I just jump in on that? Absolutely. I mean, there are some of us require that a conference like before filing motion be at least by telephone, if not face to face, whether in person or over Zoom or Teams or whatever. There's just a huge difference in the human level of interaction and actually talking live to somebody versus sending emails back and forth. And and just sort of to really expand on what both Andy and Jerron have just said, you civility is critical, and you should do it for its own sake, right? It's the right way to practice law. It's the right way for our system of justice and civil justice to operate, and at its best, and for everyone to operate at the best selves. But as I guess I just say to the young lawyers, it may seem hard to imagine now, but having been at this for several decades, I'll tell you that the way you treat not just people in your firm or your clients or even co-counsel, but opposing counsel, it's not just the right thing to do, but there are so many people whose career trajectory ends up being affected by somebody that they were friendly with as opposing counsel at some point that gives them a career opportunity 10, 15 years down the road that you wouldn't even, you could never imagine that that's going to happen. I mean, here in the Dallas area, this is a big legal market, right? I mean, we're a big top 5, top 10 legal market in America, but it's also a pretty small community. And so the way you treat folks and just trying to be, respectful and as much as possible friendly with everyone you encounter, there can be knock-on benefits down the road that you would just never even, be able to foresee, but that really do happen in real life.
Mhm.
And Andy and Jervon, I think this question probably applies more to you all. Do you typically advise your clients to attend the pretrial hearings with you? Or do you sometimes yes and sometimes no, depending on the client? And how do you kind of manage client expectations going into that?
I typically don't. I mean, I represent personal injury folks that, I mean, it may be different for Javon that has maybe in-house counsel that are lawyers that, they're going to be there giving insight. But from my standpoint, I typically don't.
Yeah, and I was just going to say that most of my clients are companies, and so they would maybe have in-house counsel, or maybe an executive may want to show up and just be a part of it. But we don't recommend it, and unless in-house counsel wants to be a part and kind of offer their thoughts. But as far as like the client representative, the CEO, or anything like that, no, not at all. We prefer probably for them to just stay clear, because no telling what's going to happen. Now, you asked the question of how to manage expectations. Again, if you are waiting till pre-trial to explain to your client that this is bad evidence and this is good evidence and this is going on and that's going on, you've waited too late. You've already done damage to that client relationship. This is a conversation that is ongoing. You're talking to your clients about this bad email since you got it, right? Since it became disclosed. So I don't think that there's any surprises that may happen at a pretrial that you wouldn't have already prepared your client for. So I don't think that there's a lot of managing of expectations in terms of we lost this, we lost this, we lost this, we won this, because you've already developed that communication and discussion way before the pretrial hearing.
Judge Horan, this is a question for you from the court's perspective. When it comes to rulings on motions in limine, and I think, Jervon, it was you who kind of mentioned that the door can be opened. What are some of the things you look for and whether or not the door has been opened, depending on what was discussed in pretrial? And is it ever possible for the side who didn't ask for the limine to kind of open their own door?
Oh, well, sure. I mean, certainly the party who did ask for the limine, if they then decide they want to blow through that, I mean, I'd appreciate some notice, I suppose, so that it doesn't get awkward between the two lawyers in the court. But I think the party who didn't ask for it can potentially open the door. I mean, just if it's just the usual analysis of whether they've taken such a contrary position, or now trying to take, kind of get into some of these sort of cliche-ish, but still, doctrines that we talk about, like sword and shield and that sort of thing, right? I mean, there seems to be sort of an unfairness in what's now going on. And bear in mind, I mean, a limine ruling is just that, either something's barred, but often what they really are is you won't present this evidence without, advising the court, and bringing it to the court in advance, and potentially through a, sidebar or a conference, outside the presence of the jury. So yeah, trials are fluid, right? That's the way things go, and so things definitely do come up where the ruling that was made, in more of a vacuum and before start hearing any actual witnesses and seeing actual evidence can change or can be changed, sort of by the actions of one lawyer or the other.
Well, thank you all again for giving us your time and your expertise and your insights. We are very lucky at DAYL to have the ability to bring some of the top litigators and trial lawyers in the area to speak to our young lawyers. And we hope that all of the participants enjoyed this and walked away with some practical tips that they could use. We do have the CLE course number in the chat, so please make sure if you are trying to get CLE credit for this to note that it's in the chat. And again, we do have the registration for our June 26th Top Gun program in the chat as well. But I want to thank all of our panelists again, and if anyone has any parting words or last things that they want to cover about pretrial or anything like that, please go ahead.
I just want to say thank you for having me on this panel. I want to say that I think one of the accolades that was mentioned about me was something about being a best lawyer under 40. I'm no longer under 40. I just want to make sure that that's clear. I mean, I know you guys are thinking that I'm talking about a lot of stuff, and what is she still, no, I'm a little bit over 40, but I don't want that to be any false advertisement on my behalf. But so I need to change that from my bio. It's a little old news now. But thank you all, and I'll just say to the young lawyers, go forth and conquer. You're going to make mistakes. You're going to have challenges. You're going to win some, lose some, but that's what we do. We keep ticking. We keep going.
Amen.
Yeah, agreed. And thanks for having me.
Thank you, everyone.